Now in session. Good morning. Please be seated. This is the time set for oral argument in 1 CR 210148, State versus Teran. Counsel, we have read the briefs. We've discussed this matter in conference this morning. Both sides have 20 minutes to present their argument. Please remain at council table when you're making your argument. And with that, you may begin.
Good morning. May it please the court. My name is Robert Trebelcock. I represent George Anthony Espinoza Teran in this case. I raised 4 issues in my brief. I'd like to address the first 2, reserve a little time for either rebuttal or to maybe get to a third issue. The first issue I'd like to discuss is the court's refusal to give jury instructions regarding the duties of the driver and the unfortunate victim of this traffic accident that happened in Yuma, who was crossing the street.
Counsel, does your argument turn on whether it was fundamental error or regular error in this case?
I don't believe it would turn on either one. I think it would fall under both, Your Honor.
Is there sufficient record for us to determine that there was error, or are we reviewing this for fundamental error?
If I can give a little context to if you read and I believe it was on day 11 of the trial, toward the end, it's about on page 180 something. I believe that's where the discussion came where...
We're talking about the second trial.
Second trial, I'm sorry, second trial, where there was a long discussion as far as if the lesser included was going to be given. At the end of that exchange, in kind of an offhand comment, and we have to remember this was during COVID, I think they spent the first 6 days with all the procedures just picking the jury. It was still a fairly new procedure at that time. I think there was a little bit of a effort to get the trial moving because we were up to day 12 approaching that. So at the end of this long argument, the court denied the lesser included on the 28-672 and then just made, counsel, you raised the issue, you filed your motion, I'm denying that, and then basically had said, do you have your record? I don't have the exact words, and I think at that point in time, counsel probably felt that he didn't need to go further. Even if that's not the case, if the court doesn't believe that.
Was there a settlement of these instructions off the record?
I'm sorry?
Was there a settlement of the instructions off the record?
Unfortunately, yes. And I don't believe that's an unusual practice for you. I've only been there about 3 years, but that's not, a lot of things do happen in chambers, and a lot of things do not get put on the record. It's not to say that the attorney is not supposed to do his due diligence and to make sure that the record is established, but I think in the whole context of where we were, right after a big long argument, judges wanting to get this trial over with, we're coming into the last day, I can understand how counsel would kind of think with that sort of brash little offhand comment that the record has been sufficiently made as far as the court was concerned. But I understand that this court may not agree with that, but I don't think that's fatal to our argument, because I think this would be a fundamental error regardless, because this deprives Mr. Teran of an important fundamental right that he would have, which is to have the jury instructed on any reasonable theory by the defense. And
I have 2 more questions in that area before you get to the substance. And that is, didn't the state originally ask for those particular statutory instructions?
They did.
Did they ever withdraw that?
Well, the context of this was the trials happened about a year apart because of the COVID happened. The primary attorney He's now retired, but he was, for lack of a better term, he was a senior. They had a junior attorney. The first junior attorney, Mr. Salisbury, he was the one who filed those, requesting those specific instructions, 792, 793, and 794. By the time the second trial came, there was a new second chair prosecutor, Mr. Severson. For whatever reason, those did not carry over because we not only had a new prosecutor, but a new judge.
Were they officially withdrawn? And if so, where were they officially withdrawn?
I do not know if they were officially withdrawn. I did not see anything in the record that they were officially withdrawn.
Just because there was a second trial doesn't mean that the original pleadings needed to be refiled.
And I would agree with that, Your Honor. But the court did, but I don't believe the court in the first trial, even though it was a different judge, I'm not sure if they had actually ruled on those yet because they hadn't gotten to closing.
But again, did the state ever withdraw their request for those instructions, either on the record or in a plea?
I have not seen that, Your Honor.
Okay.
Did defendant re-request in the second trial a new set of instructions? Or did he also rely on the instructions that were offered in the first?
He filed. He did not ask for 794, he asked for 792 and 793. But again, I'm not privy as to what was actually said back in chambers. All I know is...
So, let me ask you this, and I'm sorry to interrupt.
Oh.
But because you said the court refused the instruction, we don't have that in the record. All we have is they came out of a room, and I'll use the Hamilton reference, and we weren't in the room when it happened. So how do we handle that? What do we say? Whose burden is it when they go into a room that the judge asks them to step into and there's no record?
Well, I think the rule is pretty clear, 21.3, and it does say that for jury instructions that the counsel needs defense, the party that in this case would be defense, does need to make sure that there is a sufficient record. And I have to concede that part of it.
So are you conceding that we have to review this for fundamental error? I mean, what obligation is on the court to have those instructions discussed on the record?
Again, I'm not conceding that point, but my argument would be is even under fundamental error, this would qualify. Because it's depriving Mr. Teran of a substantial right that he has, which is essentially to be able to present a complete defense, to have the jury adequately instructed on his theories of the case. And that was not done in this case.
Is it the court's obligation then to hold that on the record, or is it defense counsel's obligation to create the record?
I would say it's both. The courts certainly have an obligation to make sure that things are done right, and if they see something that they're concerned about, they can either, whether it's taking judicial notice like we had asked in another part of our brief on the crosswalk issue, or if it's just to even bring it up to counsel's attention to see if it needs to be addressed. The fact that this was a little rushed, given all the circumstances, I think it was probably a failure on everybody's part, and certainly everybody, including the prosecutor, has an obligation as a minister of justice to make sure that everybody's rights are protected, the victims, the societies, as well as the defendants. So it's primarily the defense attorney, I will concede that, but it's not as if no one else has a role in this.
Well, the defense attorney didn't control whether court reporters in the room, did they?
I don't believe they did. I've never seen my limited time in I've never seen a defense attorney insist on a court reporter in a chamber setting. But as I said, the reason why this is important is because the state, in order to convict Mr. Teran of manslaughter, they had to prove that there's a gross deviation from the standard of what a reasonable person would be. And without having the jury having an understanding of what everybody's rights or obligations and duties are as pedestrians versus vehicles, there's no way that they can get a starting point to even make those decisions. People who drive, people who walk on the street, we don't do this in a vacuum. Everybody, as they come to critical points, have certain obligations and certain rights, and they kind of overlap at times, but there's usually primary and there's usually secondary rights. And so...
Can you tell me how the victim's duty impacts the defendant's duty? How do we factor that in a criminal case where the victim's duty is really not at issue?
Well, the duty, it may not be the jury's decision to whether or not to convict or not convict the victim and something like this.
It's not an allocation of fault.
Yeah, right. But that doesn't mean that they can't, when you're looking at a standard that says we're going to be so far off of what the norm is. And so certainly people have a right, and I'll use it from Mr. Teran's perspective, as he's traveling down this 2-lane road, and he's familiar with this area. He went to school there. He's 21, the victim is 15. He knows this area. He describes this area that they had walked to as a chill area. At one point he says what everyone does is they walk halfway, wait for traffic to clear, and then they go. So that's his expectation as he's coming down the street. Now, you do have to reasonably expect maybe someone is going to do something improper, but the reason why that 792, and to be perfectly clear, it's 28792, but why that is important is if that's what the jury believed, that's the worst case for Mr. Teran. That's the one that says that area right there, which we are not conceding, but that was a crosswalk. Okay, that's the worst case scenario for him. He has certain obligations as he sees people approaching that may or may not be in danger. But once it looks like they stop, or he perceives that they stop, now there's a second part to that statute. The second part says that not just the driver has a duty, but pedestrians have a duty not to just step in front of a car that has no chance to stop or to avoid or to swerve or do anything. And so when you're looking at it from his standpoint, if this had been a child of 4 or 5, that's probably a different expectation and a reasonable person would probably take a little bit more precaution because we expect 5-year-olds.
So let me pick at that a little, and I don't think this is a complicated question. It's not so much that she had a duty to stop, it's what he would have expected her to do in terms of formulating whether or not he was reckless or criminally negligent. It's from his perspective and the impact that duty has on his thought process, not anything to do with her in a sense.
That is true, Your Honor, and I would agree with that. And I think the court had picked up is that this is something that the state had originally asked for, never withdrawn. Nothing had changed in this case from the time of the first trial to the second trial. There wasn't any new evidence. There wasn't anything else that would change what this relationship was. So I think one of the things you may indicates that how important this issue was is not the second jury, but the first jury. If you look at those juror questions, one question was she jaywalking? Was it legal? That was one specific question. Another one was asking about were the crosswalks
What was
marked?
the response to that question?
I'm sorry?
What was the response to the question?
I do not recall, Your Honor.
Again, this is a kind of a procedural question. Didn't trial defense counsel argue the statutes even though they weren't given? And didn't he make the argument that there's an obligation not to step out in the front?
Yes, he did, but you have to remember, when you look at all of the testimony that surrounded that particular part of it, there was some hedging. They never actually, I think, even read the entire statute other than the crosswalk. They read the crosswalk and that to the jury, and then that got into the closing instructions, but they never actually read word for word. It was always, well, doesn't the driver have a general obligation to avoid hitting things? Yes, they do. Doesn't the pedestrian have an obligation, which was 793, to not, if they're not at a crosswalk, to walk in. They never had specific instruction that they could take back, given to them by the judge, not just two attorneys arguing back and forth, but something they could go back into the jury room, look at it, study it, see if it applies.
Well, I thought the case law was that in determining whether it was error for failure to give an instruction, we could consider both the evidence and the argument of counsel. And if you're telling me that the evidence was that the jurors were made aware of it through the evidence, and the argument of counsel is that he argued the legal part to the jury, why wouldn't that be sufficient for us to say, even if it was error, it was harmless in this case?
Because when attorneys are formulating their closing arguments and lots of words are being said, it's easy to kind of have the jury kind of get lost in so many things. You can make the argument then and say these things, but without the actual language for the jury to go back and study to see if does it apply, does it not apply, because obviously the state was arguing something else.
So counsel for the state, the prosecutor, argued contrary.
Yes.
He argued, I'm assuming it's he, I don't have a recollection at that point, but the prosecutor was saying that there was no obligation on the victim. The victim had no duty.
I wouldn't quite say it that way. It doesn't matter what she said, whatever she did. In fact, in paraphrasing, it was something to the effect of, she could be lying in the street and he has a duty to not hit her. That's true. But that's kind of misstates what this situation was.
And I know I'm sorry, go ahead and finish your
No, I'm
Well, I'm cutting into your time, but are you saying the instruction should be what defense requested? Because we're recognizing that it's not a duty kind of instruction. How do we instruct the jury? What words do we use to make that clear so that they're not trying to allocate fault in a sense?
Well, I think it's still up to the attorneys in their closing arguments, but the difference is if you give them the statutes, if you tell them this is what the duties approaching this area, whether a crosswalk, whether it's not a crosswalk, it really doesn't matter, because I think you can get to the same point, is in the worst case scenario for Mr. Teran, we still have the victim having the obligation not to step in front of a vehicle, especially when in this situation under these facts, it wasn't as if someone was running across the street full tilt. It was three young 15-year-old teenage girls who were kind of walking, having a good time, looking like they were aware of things, at least enough. They were able to cross the street. There was another person coming from the other side who testified. And I think what was very telling is one of the girls who was with the victim in this case, her testimony was that they saw the cars, they stopped. She didn't see what the victim did, but she heard her say, "Let's go." I think that's something the jury should be able to assess as to, had they stopped, did he have a reasonable basis to expect that they were not going to step into the street? And if that wasn't reasonable, how far off of the norm would that be for someone, teenager, grew up in that area, sees teenagers, knows how that area kind of works? How unreasonable would that be? And that's where I believe that the fundamental error would have occurred in this case, because it did deny him a substantial right. I said I've got about a minute and a half left. I'm not sure if that's enough time for rebuttal, but I'd like to say that if I could.
All right, thank you, counsel. Ms. Clay?
Good morning, Your Honors. May it please the Court. My name is Grace Cynthia Claw, and I'm here on behalf of the State of Arizona, the appellee in this matter. And I'll begin with where the Court just left off in discussing the first claim. No fundamental error resulted from the absence of the crosswalk or the right-of-way instructions at issue. And before I get into this, I do want to acknowledge, in case the court has not had a chance to read the state's notice of errata filed on Friday, that the trial court did in fact give the statutory definition of a crosswalk as part of the final jury instructions. But that...
I just want to follow up a little bit on the point of review. The state asked for the duty, I'll call them the duty instructions, the obligation instructions of the pedestrian and the driver.
Okay.
The state asked for those instructions originally.
That's correct.
Did the state ever withdraw that request?
There's nothing on the record to suggest that they did.
Okay,
So
so
it might have happened in Chambers conversation.
in the mysterious milieu of what happened off the record. So the state asks for instruction, the defense asks for the instruction, and the court doesn't give it. Why should we review that for fundamental error?
Well, we should review it for fundamental error.
Why? Both sides requested it, and we have no idea. So you're not disputing that it should have been given because you requested it below.
The state did request it below, but for all we know, the state might have withdrawn that as part of its in-chambers conversation.
Wow.
And we're not contesting that it should have been given. Or we're not saying that the instructions should have been given. We're actually saying that there's nothing on this record to suggest it was offered or requested for a proper purpose. And for that reason, under Rule 21.3,
Wait a minute, hold on. You lost me there.
Okay.
The state requested it, the defense requested it. How could it not be for a proper purpose? Both sides wanted the instruction.
Well, we don't know for sure what the purpose was that the defense counsel had requested it. And I can't say what was going through the prosecutor's mind in as to why they withdrew the request, which I'm assuming that they did. But it still wouldn't be error. And going to what the court initially had asked, what standard of review should we apply here, it would be fundamental error, because really nobody knows for what reason the court denied it, and we don't know for what reason the parties withdrew it or had requested it. And under Rule 21.3, it is the party's duty, the proponent of the instruction, to preserve the objection to the ruling on the record and with the requisite specificity. And here, defense counsel didn't do that, so the court should have applied fundamental error review. And in doing so...
well, let's go back to what Judge Goss was asking. Whose obligation is it to hold a hearing, to have a record?
It would be the party requesting the instruction.
I thought the trial court was responsible for the record.
Well, for the record, yes, but for preserving an objection, it would be up to, in this case, the proponent of the instruction.
Do you agree with defense counsel that when they finally did get around getting on the record, he said, you've got your record, indicating whatever you needed to make, you've made?
Again, that might have been true for the lesser included offense instruction, but he still had an obligation to preserve his any objection to the denial of the other instructions. So again, this fundamental error would apply, and under that standard of review, opposing counsel, Teran's arguments fail, because at this point, he has provided nothing in the record to show that these instructions should have been given. He only speculates that they would have been provided for a proper purpose. And in fact, the record shows contrary to that, because what we have is, in his closing arguments, defense counsel essentially argued that the crosswalk instructions really didn't matter whether a crosswalk existed or not. What really mattered was the fact that the victim had just jumped in front of the defendant's car, and the defendant did not have time to stop. That doesn't hinge on the existence or the absence of a crosswalk. And therefore, the question of whether a right-of-way existed on either side also wasn't necessary for his defense. And going that also goes to why any error, if we were to assume there was error, would neither be fundamental nor prejudicial, because the record shows none of these instructions were essential to Teran's defense.
Go ahead.
Well, to follow up on what you said, would you agree that this is the whole reason for these instructions would be for the jury to calculate the defendant's state of mind? It has nothing to do with the victims, correct?
That would be a proper purpose, yes.
So the defendant didn't get the instructions that we're talking about. And so obviously that could impact how the defendant approaches his oral argument. Would you agree? Or his closing argument?
In theory, yes.
All right. So in this case, if what we're talking about is whether the defendant could expect what the defendant could expect of a pedestrian, doesn't it make a difference if you're going 50 miles an hour or 40 miles an hour, whatever the speed limit is, and just driving up the street and see a pedestrian versus seeing a pedestrian approaching a crosswalk?
And yes, that is an argument that
And so
could be
why
made.
is that not an instruction that's absolutely necessary in this case?
Because it wasn't an argument that defense counsel or trial counsel had intended to make. And we know
But counsel, you just conceded that he made the argument after he was refused the instruction.
well, he was made the argument that the victim had jumped in front of his car. He didn't make an argument that she had to yield to him. So, and I think there is some confusion here because we're talking about 3 different legal principles that are embodied within the duty statutes, and 2 of them really didn't matter to his defense. The only one that mattered was this common sense idea that a pedestrian shouldn't walk in front of an oncoming vehicle that's too close to stop. The jury didn't need an instruction to know that in order to give any effect to the defense, that the defense theory of I couldn't stop in time.
If that's the case, then why was the crosswalk instruction even provided?
I can't say why it was provided, other than there was a lot of discussion about a crosswalk, and maybe that was in response to one of the jury questions from the first trial. I can't say it's exactly why it was provided. But that said, defense counsel admitted as part of a Rule 20 argument that the crosswalk issue wasn't even significant to his defense in light of the fact that Teran admitted multiple times to the police that he believed that this was a crosswalk. And that was more compelling, since we're talking here about the defendant's state of mind. What he believed at the time was more compelling than whether or not this pathway constituted a crosswalk as a matter of fact. So again, when we're talking about the different instructions here, the fact that the jury received a statutory instruction for the crosswalk was sufficient for it to make any determination as to a crosswalk if it needed to. But again, the issue of a crosswalk wasn't significant to the defense. And when we're talking about the right-of-way instructions, there is nothing in the evidence to suggest that defense counsel had offered it for the purpose of lessening culpability. And it is his burden on appeal to prove that that was the purpose for which he had requested it. But in fact, on the flip side, there is evidence in the record that shows that he requested the right-of-way instructions in connection with his lesser-included instruction, which, as a matter of law, the misdemeanor offense in that instruction did not constitute a lesser-included instruction. And it would have made sense that the court then would have denied the right-of-way instruction, since it was sort of almost a package, and it went towards this idea that a misdemeanor traffic violation causing a person's death would constitute a lesser-included.
Counsel, I still struggle with the idea that the state can request an instruction because they think it's relevant, and then the defense requests the same instructions because they also think it's relevant, and that we have a silent record, but we're supposed to say those 2 requests were for improper purpose on appeal.
We're not saying that they were, the state's not saying that they were, as for a matter of fact, submitted for an improper purpose. It's not our burden to prove that they were requested for an improper purpose. It's Teran's burden to prove that they were requested for a proper purpose and the court denied it. And here there's nothing in the record, and defense counsel or opposing counsel doesn't cite to anything in the record to show that he actually had requested this as for a proper purpose. The entire opening brief and the reply seems to be just based on the speculative theory that this is the reason why he would requested it, but there's really nothing to show that that was his purpose. And again, when you look at the context in which it was requested, which was in connection with the lesser included offense, the more reasonable, or there is that indication that his only purpose for requesting the right-of-way instructions was to support his theory that if anything he was guilty of what he believed was a lesser included offense, which by law really was not. So again, it would have been reasonable for the court to to deny the request to include the right-of-way instructions. And again,
Did the state argue that the right-of-way, what you refer to as the right-of-way instructions, how did they argue or phrase that argument in response? How did they address that in their closing argument?
the state didn't actually make any arguments about right-of-way, about which party had a right-of-way or a duty to yield. And they didn't do any sort of argument about, they didn't apply the facts to try to argue this was a crosswalk, and as well as opposing defense counsel also didn't make an argument as to who had the right-of-way or not. And even also, defense counsel didn't make any fact application in closing arguments to suggest that this was not a crosswalk. As far as he got was to say, well, Detective Carrillo said it wasn't, so you shouldn't make this a more serious case because of a crosswalk. That's the most that he got out in his closing argument with regard to it. And again, what's really, I think, what might be really helpful to the court is to just look at the right-of-way, the duty instructions, and actually what they say. And they lay out 3 legal principles, and only one of which we could say had somewhat of an impact or could have had a minimal impact on the defense. And that is this common sense idea that a pedestrian should not walk in front of a vehicle when the vehicle is too close that it cannot stop. That's the only one that defense counsel had relied on in closing arguments. And the fact that his only defense witness was presented for that explicit purpose to establish that even one of the people who was with the victim at the time in the median, even she didn't want to go, and it surprised her that the victim had stepped out onto the street. I mean, that's exactly in line with what defense counsel's theory was, and it had nothing to do with who had the right-of-way or not, or whether there was a crosswalk that existed. And the fact that the only witness the defense presented focused, or their testimony went towards just this one theory, tells us that it was the plan all along to only present this one theory of defense, and it did not have anything to do with the right-of-way instructions. And again, I think it is significant as well that defense counsel knew in preparing for this trial that he knew that his client had admitted multiple times to the police that he believed that the paver pathway was a crosswalk, and he knew how it worked. He grew up in the area, he went to school in the area, and so he was very well aware of how this particular pathway was utilized as the crosswalk. And again, that would have been more compelling evidence to the jury as to the defendant's state of mind than to whether this pathway constituted a crosswalk. And I think knowing all that in advance, defense counsel chose a theory that was going to be the most beneficial to him, which would have been just this common sense idea.
And doesn't your argument make the point of how important that argument really is in this way? Or in how important the instruction really is in this way?
Not necessarily.
No, wait. Okay, I haven't actually asked the question.
Okay.
The question is, when we're looking at jury instructions, most parties will even put them up on a big screen. This is what the judge just told you. If the judge had just said, by the way, if this isn't a crosswalk, the victim shouldn't step out in the street in front of a car, defense counsel almost certainly is going to put that up on the screen, and the jury's going to look at that differently than just a silence on what the law is. Wouldn't you agree?
Yes, that could be possible, but here again, Detective Carrillo provided the substance of this particular statute that said a pedestrian must yield to oncoming traffic if they're crossing outside a crosswalk. If that really was essential to the defense...
Isn't the state arguing two things then? Well, the defendant thought it was a crosswalk. His duty was this. And but the state's made the point that it's not the crosswalk. And the jury has to sort that out.
No, the state wasn't necessarily, the state's theory didn't rest on, again, the presence or the absence of one. They're more or less focused on, regardless if there was one or not, the Teran had a duty of care, and he had a duty of care in the way that he drove.
However, counsel, if the decision was made to present the definition of crosswalk, or present it to the jury and have the jury decide whether or not it was a crosswalk, wouldn't it have been appropriate to give them the full picture of what, whether the jury thinks, yes, it was a crosswalk, so here are the pedestrian and driver duties. No, it wasn't a crosswalk. Here are the pedestrian and driver duties. Why wouldn't that be critical?
I can't say as to why, again, they weren't requested on either side for expanding the duties, but the fact that here it wasn't essential goes to what any error, if we were to assume that there was error, just wouldn't be fundamental or prejudicial. So,
And if we disagree with you and say, no, this is just regular error, okay.
Then it would still be
Can we say
harmless.
this is harmless beyond a reasonable doubt?
yes, because again, you have to look at the three legal principles that are embodied within these, what I call the right-of-way statutes, and only one of them mattered. And even to the extent that it mattered, it had very minimal value because, and let me just back up a little here. So the first legal principle I'm talking about basically requires a driver to yield to a pedestrian who's crossing in a crosswalk. That actually went against the defense's theory that there was no crosswalk. So that would not have been helpful at all. The second legal principle in these statutes says a pedestrian must yield to a driver when crossing outside of a crosswalk. But that's exactly the language that Detective Carrillo provided in her testimony. And it's something that Teran could have drawn upon in closing arguments, but he didn't, which only goes to show that that particular statute was not essential to his defense. And the third legal principle was this common sense
Hold on,
idea.
because I really think you really keep losing me there.
Okay.
It is essential to his defense because his defense was she stepped out in front of me.
Right, and that's the third legal principle. It's confusing because there's two statutes, but in one of them there's these two principles, and the second one of that is this common sense idea that you should not step in front of a vehicle that's coming so closely that car cannot stop. That one did have some relevance to his defense, and if we argue that that was error to not give that specific instruction that says the victim or a pedestrian should not step onto the roadway, then even if that was error, it would be harmless because defense counsel still made the argument. He didn't need to say there's the statute that exists that tells you exactly what a reasonable person wouldn't do. And again, it was just common sense codified. The jury didn't need an instruction to say this is what a reasonable pedestrian would do. I mean, no reasonable pedestrian would step out in front of a moving vehicle. So to the extent that it was error to not give that specific instruction with regard to not stepping out in front of a vehicle, it would be harmless because it's something the jury would have understood. It was an argument that defense counsel made. He didn't need it. And on top of that, I think we also have the verdict to show that there was also some proof there that the jury agreed somewhat with defense counsel's theories that this was not a crosswalk. And I mean, if they even got to that point, because they acquitted Teran of the more serious crime and only found him guilty of a lesser culpable crime.
Just so I'm clear, counsel, your position is that the exclusion of the right-of-way or duty instructions was not error, period?
Yes, not error, period, because we have nothing in this record to show it was offered for a proper purpose. And I think it's just pure speculation on appeal that it had been requested for a proper purpose.
But I thought in your answering brief, you conceded that those laws, would go to some of the statutory elements of the crimes with which he was charged.
We conceded that it's relevant if it had been offered for a proper purpose, and I think it's a little confusing here because Teran's position on appeal is actually contradictory to what his arguments in his defense was at trial. At trial, his position was the crosswalk and the right-of-way and the duty to yield statutes were insignificant to my defense because Teran admitted he thought this was a crosswalk, period. So it wasn't essential. The only one that was essential was this, or not essential, but it could have been helpful, was this, I'll keep referring to it, this common sense law. But again, it was harmless because Teran still made that argument. And it was just, again, a common sense idea that the jury would have known and they didn't need a statute or an instruction to tell them this is common sense.
So you focused on proper purpose here. Oh, I'm sorry.
No, that's fine. Go ahead.
You focused on proper purpose here, and that's a reason why it was an error for them not to be included. In your brief, you talk about how it would have been misleading and confusing for the jury to include these instructions. Can you explain why?
Yes. because, again, I think everyone's kind of speculating to some extent as to why these were not included, the right-of-way instructions specifically, but it's not state's burden to prove. It was offered for an improper reason. But our argument as to why they were misleading was based on the fact that there was no other guidance in the instructions that would have told the jury, this is how you kind of use this, and there was no closing arguments that told them, here's the significance of the right-of-way and the duty to yield laws. And the fact that 2 to 3 of the legal principles in these right-of-way statutes focus on the victim's conduct without any guidance or arguments, it was possible that the jury could have used the victim's conduct to somehow negate Teran's culpability, which we know is an improper defense in Arizona. And the fact that there existed this potential to mislead the jury, that made them proper or appropriate.
Thank you, counsel. Your time has expired.
Okay.
Thank you.
The state rests on its briefs and asks the court affirm Teran's convictions. Thank you.
Counsel, and given that the state went over, we'll give you an extra minute.
Thank you, Your Honor. I think the only thing that I would want to address in my remaining time, and might not use it all, is that if I understood counsel correctly, is that she was saying that there were, because defense counsel or even the state's counsel generically talked about things, that should be enough. There's a big difference if you look at the record and you look at what all the testimony was about the right-of-way, and I think that's a good way to phrase this, about the right-of-way, is that the very generic statements, and there weren't any real solid ones other than, well, yeah, I think that there's a duty to stay out of the way of the car if you're the pedestrian, and you have a generic duty. That's a far cry from, and when you ask for specifics, say, just give me what the statute is, and I can point out to the jury, this is why it applies. This is why it applies. You don't even know if the jury even took notes on those particular aspects. So it did handicap defense counsel and possibly even the state, but it handicapped, I think, everybody to be able to really get down to the essence of what this case was. This case is about rights and duties vis-a-vis a reasonable person in Mr. Teran's position. And it was impossible, I think, to ask for the jury to make those decisions without that. And so that's why we think that whether it's harmless or whether it's fundamental, we think that error occurred that should be reversed. Thank you.
All right, thank you, counsel. The matter has been deemed submitted. Thank you very much for your briefing and your argument. We'll issue a decision in due course.